Greetings and welcome to Law of Evidence, Incidents of Human Life from American Jurisprudence. Let's get this thing started here. All right, and just check in with the chat. Welcome to everyone. Please hit the like if you just joined. Bill Thomas asked, how far from freedom have we fallen when they stop to just look up your tailpipe? Yeah, I think it all started with when employers were really interested in, the contents of their employees' urine more than their performance. And I think it's gotten to the point where the government's more interested with what's coming out of your tailpipe than the performance at the wheel. That being said, let's get started on tonight's presentation. We are going to be looking at Law of Evidence from American Jurisprudence. This is from a 1998 edition. However, it is, all these principles still hold true. There are some supplements in here with some from the 98 holdings, and I'm sure there's been some more recent ones. But for the most part, we're here to learn the fundamentals of the American jurisprudence principles. That being said, just remember that this broadcast is strictly for the purpose of this YouTube channel only, not to be used, misconstrued, mispurposed, or unpurposed for any kind of thing that's legal, lawful, personal, private, financial, business, tax, or otherwise. So please don't do this at home. That being said, and just as Bill Thomas was saying, California is conducting roadside smog inspection checkpoints. And I think what that really means is that the freedom is really a function of how much that the population is willing to regulate themselves, and I think that's part of what the whole spirit of independence is about. And when that is abused, we're back to the tragedy of the commons, and that's not really where we've excelled as a nation here in those kinds of detriments. Rather, the fact of people being conservative enough and self-regulating enough to make sure that there's plenty for everyone, as this land has been able to provide, it seems only prudent that we preserve it, or not preserve it, but conserve it so that it's well used and well left for others to use and enjoy when we're gone. That being said, let's get started. Let's see here. There we go. So we're on to Chapter 2, the characteristics of people, incidents of human life. So we're going to start with section 54 generally. And we're on to the judicial knowledge. So back here to judicial knowledge. Remember, judicial notice doesn't always equate with judicial knowledge. So let's focus on what they're saying here as judicial knowledge. And let me just make sure I'm here refreshed properly. This is strange here. Just checking on the channel. There we go. And let me just do one more quick housekeeping chore here. And professor of stuffology, I think the issue is fundamental law. We don't argue constitutional text. Well, we're not here to really argue at all. We want to be able to make avertments of statements of fact and truth. And this is being based mostly on common law, which is the underlying principles behind American jurisprudence. And that being said, let me just do one quick housekeeping chore here so we can get this stream started and moving smoothly. Just a moment here. That being said, please hit the like if you're in the chat. Morning, night, afternoon, depending where you are on the world. And give me one more second here. I want to try and make sure that this is getting out to everyone because it seems like the notifications didn't go out last time. And we need to make sure that the other one is gone. And now it is. So we should be good to go. All right. We have a right to privacy and due process. Due process has been altered without authority. In fact, understanding due process and where it applies more fully allows us to at least stand on it and not have it hope to have it handed to us. All right, so morning for the professor of stuffology. Well, greetings to you. Let's get started. Judicial knowledge comprehends information and beliefs relating to human activities, habits, traits, diseases, and propensities. Let's break this down a little bit here. It seems like they're just throwing some words here, but we have judicial knowledge comprehends the information and beliefs that relate to human activities. So activities, human activities, there's no reference here, but things that humans do, actions that they do, their habits, those would be their repetitive activities. Traits, which would be characteristics or attributes, perhaps. Diseases, which would be a misdirection or a performance of activities. And propensities. So propensities being used here is meaning a habit or something of choosing particular behavior regularly, as opposed to, say, proclivities, which would be the regularity of choosing something or having a tendency to choose one thing or another. So propensity is having a regularity of behaving a specific way. So that's all is encompassing within judicial knowledge. Courts have taken judicial notice. Okay, so you'll make judicial notice and hope that they can comprehend judicial knowledge from it within the course of the case. The information and beliefs, right, relating to the habits, traits, diseases, propensities, human activities. The courts have taken judicial notice of the behavior, characteristics, and needs of children, teenagers, college students, parents, and senior citizens. So we're classifying them where these particular aspects of knowledge would apply. So it seems like the judicial knowledge also requires the subject as well as the belief. All right, courts judicially may notice facts concerning life and life expectancy and death, food and drink, and clothing. Judicial notice about clothing. That seems interesting there. Just a moment here. Bill Thomas, yes, deep definitions is the point of being here, not just reading through it. I find that American jurisprudence is very densely written. The information is so dense that there's very little puffery along or any kind of excess words. It's not a very wordy type of informational guidance. It's more of there is repetition in ways, but it's done with a purpose. So I think that it's truly written to have every word tell. All right, let's move along here. Judicial notice has been taken that racism still plagues many aspects of life in the United States. And a court may take judicial notice of the distinction between a party's cultural ethnicity, for example, Puerto Rican, and their race. That's footnote 16, obviously involves a Puerto Rican. Courts may also notice that sometimes people are motivated by economic concerns and sometimes by altruistic interests. They have taken judicial notice of what people read and what they do not read. In addition, courts may take notice that sports can be hazardous to the participant and the spectator or innocent bystander alike. That productivity decreases and the volume of mail increases before and shortly after Christmas. And that political parties compete for the farm vote. Wow, so these are all things that judicial notice has been taken of. Now, whether it was, fully taken in as evidence is not certain. However, the fact that all of these things do qualify as judicial notice, does give an option to at least have it brought noticed by the court. The court may not, however, take judicial notice that the phrase going with means that the parties involved are engaged in sexual relations, as the meaning of this phrase is subject to reasonable dispute. Going with is not going to be your judicial notice. It means it's your squeeze. All right. On to section 54. Well, this is generally the supplement here with our 1998 supplement. Case authorities. On motion to dismiss for lack of subject matter jurisdiction. Plaintiff's complaint alleging, inter alia, that drug enforcement agency stalked and harassed plaintiff. Court would take judicial notice of the fact that there are psychiatric conditions which cause individuals to exaggerate life situations, including ordinary conversations, slight and encounters, and interpret them in highly self-referential fashion. I think this is slight, like with an E too, E-I-G-H-T, slight, and encounters, and interpret them in highly self-referential fashion. Okay, this is probably verbatim from the case, and of course, American English, we can use it as slight with an I. Stanford versus State in Florida, Footnote 5. And that was referring to, okay, teenagers. College, that's teenagers. And we have Seminole, Bob Butterworth. Yeah, he was the director of Commerce in Florida in the Southern District. That's footnote 8, and that was referring to which judicial notice here? Senior citizens. Interesting. All right. Here we have Berry versus Springdale in Arkansas. It is common knowledge that many people who fall asleep in their cars with the engine running and windows up have been asphyxiated when the car exhaust system or heater is defective. Many apparently accidental deaths are actually suicide. Wow, didn't know that. So, there's an interesting thing where, common knowledge. And then here's another one that's also judicially noticed. Because it is common knowledge that properly cooking pork kills trichinosis. Trial judge properly dismissed plaintiff's cause of action alleging they became infected with trichinosis after purchasing fresh pork from defendant and properly cooking it. Yeah, right. To your door pizza. Jeez. Oh boy. High proof alcohol not unsafe without a warning label. Judicial notice of intoxicating quality and the like of liquor or particular liquid from its name. Oh, that's an interesting one there too. And a person normally keeps his wearing apparel at his home. Oh gosh. The court, citing numerous court decisions, took judicial notice of the history of excluding members of racial minorities from crafts. Wow. Race discrimination in employment action brought by African American and Hispanic corrections officers. Racism in state colleges and universities. Nature of Ku Klux Klan and its history of advocating violence against African Americans. That could be judicially noticed. What else we have here? Holding that a statute proscribing direct or indirect payment as an inducement to circulate petitions to place an initiative on the ballot impermissibly interfered with the right of the initiative. Wow. So I guess they would do a judicial notice of that statute. And it held, okay, it is common knowledge that nearly every machine, device, or piece of equipment sold in the United States is accompanied by an instruction manual, sheet, or label. That these instruction manuals are usually reliable and that people usually read the instruction manuals and follow the information contained therein. That's a little stretch there. People usually read the instruction manuals. That's pretty funny. How many people in the chat know those who actually read the instruction manuals, usually. All right. It is common knowledge that consumers seldom read the detailed provisions of standardized contracts. Well, that we know. I would venture to say the same goes for instruction manuals. It's generally known the average golfer does not always hit the ball straight. What kind of judicial notice is that? All right, we're on a span of life. Let's jump over to the chat real quick. Oh boy. All right, let's get this here. Refresh fully. All right. Rights cannot be altered by legislation from the professor. Indeed. And rights are antecedent of the judiciary. Yes. I wonder if the court has taken judicial notice of hooking up. Well, going with ain't going to cut it, but perhaps hooking up might. Judicial notice of slang must change with time and location. Well, yes, it'd have to be what's in the colloquialisms, the vernacular. You probably want to define it within that. And Professor of Stuffology says the courts may not know anything unless upon oath. Subject matter jurisdiction is a hoax. So is judicial review. So we're going over some of this stuff here where, as you're saying here, may not know anything unless upon oath. But in this way, when we're talking about things that are common knowledge, it's only, you can't be unreasonable to that extent. And that's where judicial notice comes in, is that there are certain things that are going to be required to litigate that aren't going to be brought forth in the form of normal evidence like through oath and affirmations. And common law is distinct from statute and other law. And that's why to bring statute in here, as we read from one of the footnotes, is because it needs to be judicially noticed before it can be used or noticed to the court. So again, we're sticking with the common law principles here. We're taking note of how things have changed. It's just the reality of the landscape. However, it's up to us to be able to know and comprehend, understand, and enforce and aver the American principles and foundation of common law. Let's continue. We're on to section 55, the span of life. The courts take judicial notice of matters of common knowledge with respect to the span of life of human beings. For example, a court may find that it is a matter of common knowledge that a person 35 years of age, with no constitutional diseases or abnormalities, might be expected to live for a substantial number of years in the absence of unexpected calamity. Geez, Bone versus General Motors Court. Generally, the courts also take judicial notice of the existence of standard morality or life expectancy tables which seek to approximate the lifespan of human beings, particularly if the tables are set out in the state code. Particularly, Section 120. All right, before we get to Section 56, let's jump over here to the chat. Are we saying common knowledge are maxims? No. Maxims are the principles that guide the court, so they can always be, they don't necessarily need to be judicially noticed. They could be incorporated into motions and such. All right. Conception, gestation, and birth. Courts take judicial notice that only women, not men, can become pregnant. 1998, guys. That one act of intercourse is enough to conceive a child. That the male has equal biological responsibility for the conception of a child. That a young boy cannot father a child. and that the ordinary human gestation period is roughly 9 months. But that period is sometimes days or weeks longer or shorter. Interesting that you would have to judicially notice that only women, not men, can become pregnant. That's M versus Superior Court, of course, Sonoma, California. Yeah, okay. One act of intercourse is enough to conceive a child. That's Panza versus Panza. The male has equal responsibility. That's M versus Superior Court. Oh, geez. These must be interesting cases. And 32 here is a young boy cannot father a child. State versus Daniels. It is reasonably, if not absolutely certain, that an 8-year-old boy cannot become, oh my gosh, a father. This is a strange case here in Ohio. The period sometimes the period of gestation. No big deal there. Okay, made it through that section. Section 57, family relationships. Courts continue to judicially notice facts about the relationships within the traditional family. Still, courts also, however, judicially notice contemporary realities concerning non-traditional parenting conditions and arrangements, family viability and dissolution, and various implications of divorce. Courts continue to judicially notice facts. And courts also, however, notice contemporary realities concerning non-traditional parenting conditions and arrangements. Footnotes. Footnote 35 here regarding traditional family. This is Bourne versus Department of Employment Development in California. State unemployment insurance provision disqualified anyone who left his or her job because of marital or domestic duties and who was not the family's primary source of financial support. Wow, taking judicial notice that women are more likely than men to follow their spouses to a new job location and are more likely to quit work to care for young children or an ill family member. The court held that, although the provision was neutrally worded, it was intended to and did have a disparate impact upon women. The court abolished the presumption of legitimacy of a child born to a married couple. Massachusetts abolished the presumption of legitimacy of a child born to a married couple? In an adoption proceeding, the state Supreme Court refused to take judicial notice that the mother's admitted lesbian relationship would have a negative effect on her son's welfare. Man. And let's see, here's one. Spousal testimonial incapacity privilege should be limited to the witness spouse, not defendant. The court abolished the common law action for alienation of affections. Oh my God, holding that expert testimony on the battered woman syndrome was relevant and that the trial judge erred in excluding it. Holy goodness. So this is from footnote 37. This is regarding family vitality and dissolution. So as we see here, as some of these cases and the case holdings progress with time, we start to lose some of our common law foundation. And that's the importance of learning about it and what we're doing right here. So on this Wyman versus Wallace, this is in Washington, the court abolished the common law action for alienation of affections. Interesting. And this has to do with something with a judicial notice of that too. And in State versus Kelly here in New Jersey, holding that expert testimony on the battered woman syndrome was relevant and that the trial judge erred in excluding it. So I guess there was an expert testimony, expert witness, whatever you call them, that want to talk about the battered women. All right. Court took judicial notice of the recent liberation of women, recent, in denying alimony to former wife. Weckler versus Weckler. Judicially noticed that divorced women customarily are known by a combination of their first name, family surname, and former husband's surname. It's a judicial notice there. Huh? 1998. Okay, we're on to section 58, societal attitudes about sexuality. Boy, this makes you think about this was risque back then. All right, let's check over here in the chat if get anyone still in here today. I can see it's been a thin audience this time. Oh, where do we go here? There it is. All right, we're on to societal attitudes about sexuality. Court opinions reflecting changing attitudes in a variety of contexts. For example, courts have judicially recognized that pat-downs of male penitentiary inmates by female officers is offensive. In addition, while a court may judicially notice that female breasts are intimately associated in people's minds with human reproduction, while male breasts are not, a court may refuse to take judicial notice that the breasts of topless female dancers are commonly associated with sexual arousal, but that the uncovered chests of male dancers are not. Court may refuse to take notice. Good. I mean, come on. The court may take judicial notice that the public is generally aware of the type of material being sold in an establishment named Adult World. It is not how in the adult bookstore doesn't sell children's books. I get it. It is not, however, judicially noticeable that someone who leaves Playboy magazines open on a table in his office is more inclined to commit a sexual assault than anyone else. In addition, a court may not take judicial notice of the effects upon a beholder of an unseemly display of affection, as these are not so well known as to be a subject for judicial notice. It's a real schmoozer. Oh, gosh. Writ granted here on this, such a viewpoint might be subject to reasonable dispute depending on the section, sexual orientation of the viewer. I take it that's the breasts. If such results are within the knowledge of healthcare professionals, the information is a necessary part of a plaintiff's evidence. And that's 44. That was, court may not take unseemly display of affection. Oh, gosh. Healthcare professional. Oh, I get. Oh, gosh. The sponge bath wasn't a. Come on, I get it. All right. We're on to matters of public and social welfare. In general, the courts take judicial notice of all matters affecting the health and social welfare of the public, which are in accord with general or scientific knowledge. For example, a court may take judicial notice that olives are a food, within the meaning of the statute permitting the seizure of adulterated food. A court may also take judicial notice of the fact that there is a finite capacity for the storage of hazardous waste at facilities within the state, and that capacity is rapidly being reached. In addition, a court may take judicial notice based upon the availability of statistics well publicized in newspapers and periodicals that the use of illegal drugs constitutes a serious societal problem and that no segment of society is immune from this problem. Judicial notice may also be taken of the fact that shoplifting has reached serious, if not unrestrained, proportions. Oh, they think so in 98. Oh. Health diseases and personal injuries. The courts take judicial notice of matters of common knowledge relating to the health and diseases of people. Courts also judicially may notice that the public health is deeply implicated in the reclamation of swamp and overflowed lands, and that there is a great social need for adequate medical benefits at a cost which the average wage earner can afford to pay. 53. What is that one? California Physician Services versus Gears. Okay. In addition, courts may take judicial knowledge of specific facts regarding diseases or similar conditions, where the particular matter is one of common knowledge, but refuse to do so, where the matter is not one of common knowledge. Somewhat in keeping with this rule, some courts hold that judicial notice may be taken of the effects of a particular type of medical treatment or therapy. While the courts will not, however, take judicial notice of particular matters relating to medical or surgical procedures, which usually are deemed to be matters to be proved by expert testimony, some medical matters of technical cognizance are been recognized as also being matters of common knowledge, so that judicial notice may be taken of them, thus oops, okay. So that judicial notice may be taken of them, thus supplying proof of such matters without the necessity of taking expert testimony. So, it appears some matters of common knowledge that they can take judicial notice of without the expert testimony. I wonder what that could be. It is recognized that judicial notice may not be appropriate when the matter to be noticed is a question of fact at issue with the case. For example, a court may not take judicial notice of the adjudicative fact that asbestos and lung cancer in the same person are necessarily causally related, as this matter is subject to reasonable dispute. Moreover, courts may be reluctant to take judicial notice of medical matters contrary to the effect of the testimony given by expert witnesses, although in some instances a court will take judicial notice of facts concerning disease or the like, despite the testimony of expert witnesses to the contrary. Woo. Look at that one there. That's footnote 60. Mutual life insurance. Right of court to fully advise itself concerning matters properly subject to judicial notice by consulting standard factual works of reference is recognized in cases dealing with disease and the like. In addition, a court may take judicial notice that physicians constantly rely on medical records in making treatment decisions regarding their patients. Although the judicial notice may generally be taken of textbooks, and judicial notice may be taken of the physician's desk reference, the PDR, for some purposes, there are cases which indicate that under some circumstances it is improper for courts to rely on medical textbooks or other reference works in applying the judicial notice principle to matters of disease. And that one where it didn't work out well was Standard Life Insurance versus Strong. So it seems like the life insurance companies really pay attention to this one. All right, let me see here. Seems like our chat filter here. There we go. Now it's going better. All right, let me jump back over to the chat here. Oh, there we go. Let's see here. This link will take you to one of the men. I'm not sure what link this is. Will take you to one of the men about to change the judicial process next few weeks. Which link is that? Court has been noticing spicy things in this one. Yep, fun legal study. If you want to keep your audience attention, this is one way. All right, so check them out on Pacer Monitor. Who is this guy you're talking about? Let's see where I see here. Was there a link I missed? Let's see here. Hard to put the link in, but if you want to try and type it in pieces, then we can fix it up and I can post it so everyone can see the link if you have that for Professor. And welcome to Less TV. We all need less TV. From Oakland. And the professor of stuffology says there is a presumption that there are rules of what can be judicial notice based on precedents, and that goes against due process in its original form. Yeah, but there's a little bit more into it. There are certain things that need to be judicially noticed. Noticing based on precedent has to be applied in a particular instance. It can't be used in a general context, I believe. All right, and Bill Thomas, you have a neighbor there. All right, let's continue here. So on to section 61, the extent, effect, and incidence of disease or personal injury. Okay, many aspects of disease and personal injuries and resulting disability are judicially noticed by the courts, such as the fact that injuries may prove more or less serious than was originally anticipated, that the condition from injuries or sickness may improve or deteriorate, that total disability resulting from injury or disease may lessen in time and even disappear, and that persons seriously injured may not realize it until some time after the event, and that persons injured accidentally are frequently unable to correctly describe the event, and that severe injuries cause pain, that afflicted members of the body are less productive and more susceptible to injury than whole members, and that there is difficulty in diagnosing some types of ailments. Okay, we see we get a lot of weird cases here. Nothing special in those footnotes. Let's continue. The courts may also take judicial notice of the tendency of some people to delude themselves concerning their health, that seriously ill persons may continue to live for a normal lifetime, that many people suffer pain without being disabled thereby, and that people continue to work although ill. So these are some things the court can take judicial notice of. I guess it's being common knowledge, perhaps. I don't know. It's a stretch, but they have been. Again, we're just stating the landscape as it is. And let me make sure this chat is staying up with us here. It keeps dragging back from us, but now we're up to date, so we're all good. And if the professor of stuffology has a link he said in there, if there's a way you just get pieces of it or something, or if it's a YouTube link, you should be able to post it. All right, we're on to the particular diseases, injuries, operations, and medical facts. Facts. The courts have, in a number of cases, considered the application of judicial notice to proof of facts concerning particular diseases, including inflammatory diseases and arthritis, internal parasitic diseases, skin diseases, respiratory system diseases, genitourinary and venereal disease, cardiovascular diseases, blood and lymph diseases and infections, diabetes and metabolism diseases, and animal-borne diseases like bat flu. The courts have also considered the application of judicial notice to proof of facts concerning paralysis and nerve injuries and diseases, allergies, asthma and hay fever, alcoholism, cancer and tumors, blindness and eye diseases and injuries, deafness and ear diseases and injuries, tooth and oral diseases and injuries, AIDS and tuberculosis. The courts have considered the application of judicial notice to facts concerning surgery generally, amputations, tonsillectomies, fractures, sprains, and similar injuries, abortion and childbirth, and hernia. The courts have also considered facts relating to the following as subjects or possible subjects of judicial notice: wounds generally, head injuries, heat stroke, sunstroke, and exposure. Vaccinations and immunizations have also considered facts relating to subjects or possible subjects of judicial notice. Poisoning and foreign matter in food and drink, and the effect of an overdose of sleeping pills. So, footnote 7. Let's see that one. Did it say footnote 7? Oh, we're on the hundreds already. Okay. It's a lot of cases there. As Wolf Smith versus Marsh in California held to be a matter of common knowledge among laypersons that injections in the arm, as well as other portions of the body, do not ordinarily cause trouble unless unskillfully done or there is something wrong with the serum. Court took judicial notice that vaccination is commonly believed to be safe. Hear that at YouTube? Vaccination is commonly believed to be a safe and valuable means of preventing the spread of certain diseases, particularly smallpox, and that this belief is supported by high medical authority. How high are they? Okay, that's our disclaimer. Let's continue. A lot of footnotes on this one here. All right. The court may, however, refuse to take judicial notice of the medical effects of a migraine headache in determining whether a defendant's migraine headache rendered her incapable of making a voluntary choice as to whether to accept treatment in the form of a Demerol shot, in considering the party's appeal of the suspension of her driving privileges. Demerol. Ooh. All right. This is in Julian versus Folsom. It is common knowledge among those experienced in the disability field that arthritis does not immediately arise as a result of injury, but develops progressively over a period of time. Court took judicial notice that arthritis rapidly becoming so prevalent that it is common knowledge that it is a painful ailment and that no accident or injury is necessary to bring it on. Proper cooking of pork kills live trichinaea. It is common knowledge that existing lung disease may be aggravated by extreme overexertion and by certain types of danger, such as inhalation of flame and fumes and exposure to extreme heat, to which the firefighter are exposed. Holding it to be a matter of common knowledge, of which the court would take judicial notice, that syphilis, even when it results in the general paralysis, does not necessarily result in permanent total disability from the time of infection. The court took judicial notice as a scientific fact that syphilis may be inherited or acquired innocently by infection. The court stated that it is common knowledge that the fact that one has hardening of the arteries does not mean that he is a senile dement or mentally incompetent. It is a matter of common knowledge that heart attacks can prove fatal to sufferers therefrom who are not active, and that such attacks do occur while a person is peacefully in sedentary position or even asleep. The court took judicial notice that knowledge on the part of the insurer that the applicant was suffering from angina pectoris would have reasonably affected the determination of the acceptability of the risk of insuring him. This one here, judicial notice was taken that climbing stairs causes a strain on the heart of one suffering from a cardiac condition. Judicial notice was taken that many people are subject to low blood pressure and poor circulation. The court included Hodgkin's disease along with tuberculosis and cancer as fatal maladies of which the court would take judicial notice, but refused to take judicial notice that a blood infection known as streptococcal hemolytic infection was a disease materially increasing the risk of loss to the insurer. The court took judicial notice that insurance companies deemed the appearance of sugar in an applicant's urine as material to the risk. Rabies has been one of the most dreaded diseases of humanity. That's why they killed Peanut. Court took judicial notice that multiple sclerosis is not totally disabling disease in its first stages. That nerve injury does not ordinarily follow the giving and receiving of injections was stated to be a matter of common knowledge. Judicial notice was taken that paralysis of a limb may affect only the sensory nerve or only the motor nerve, but sometimes affects both nerves. Judicial notice was taken that many people are allergic to particular foods. Oh boy, that started a whole snowball effect, didn't it? Baldor versus Rogers, wherein judicial notice was taken of a concerted medical campaign to conquer cancer. Worked real well in 98, didn't it? Court took judicial notice that medical science has yet discovered no drug that will cure cancer in its advanced stage. Judicial notice was taken that wounds which do not heal over long periods of time and frequently become cancerous. Well, there is one wound that doesn't heal that does not become cancerous. And the court took judicial notice that any liquid heated to 880 degrees Fahrenheit and coming into contact with any part of the human anatomy probably would cause injury. Only 880 degrees, maybe 800 degrees wouldn't be enough. And that this is especially true when the liquid comes in contact with the delicate membrane of the eye. Goodness. Judicial notice was taken that an infected ear canal coupled with Peoria would not cause total and permanent disability within the meaning of a group insurance policy. Court stated that it could not assume in the absence of proof that deafness in the left ear will render the hearing in the right ear more acute, as this is not a matter of general knowledge of which it might take judicial notice. Judicial notice was taken that the extraction of a tooth done in a reasonable manner will not ordinarily result in the fracture of an adjacent tooth. The court judicially noted that the malformation or poor adjustment of false teeth may result in poor digestion and cause physical discomfort, nervousness, mental anguish, mouth lesions leading to infection and serious illness. So the court judicially noticed that. Seriousness. The judicial notice of diseases of similar conditions affecting human beings. Judicial notice was taken that tuberculosis and constipation are physical diseases, not necessarily related. Court took judicial notice that even minor surgery is fraught with danger and that good professional judgment at times requires leaving the patient to restorative process of nature, aided medicinally rather than by surgery. Court stated that surgery and the necessity thereof, therefore, and the effect thereof are in most instances not a matter of common knowledge. It is common knowledge that surgical operations of any kind leave scar tissue, and quite often there remain permanent tenderness and discomfort in the area of the operation. Judicial notice taken that due care by a surgeon is lacking if surgical instruments, sponges, or medical supplies are not removed before an incision is closed or the wound heals. No kidding. All right. Noticing the jury's common knowledge that the amputee suffered pain. Court took judicial notice that persons who have lost an index finger have little difficulty in securing gainful employment and experience very little inconvenience in satisfactorily discharging the duties of such employment. Gainful employment. Is a matter of common knowledge that old scars are often sensitive and that amputation is frequently followed by suffering and discomfort for a long period of time. Stating that it is a matter of common knowledge that a distortion in the bony structure of the body, once union and healing are complete, will not ordinarily correct itself. As whether the fracture of an ankle could give rise to varicose veins and shortness of breath cannot be said to be a matter of common knowledge. Shortness of breath from the ankle. Huh. Here's refusing to take judicial notice that an abortion can be commenced and carried to a fatal termination within a short period of time. The court say that a fact of matter common in general knowledge that pregnant women sometimes miscarry and sometimes have stillbirth, and sometimes children born alive die very shortly after birth. Court took judicial notice that is reasonably, if not adequately certain, that an 8-year-old boy cannot become a father. We saw these, okay. Sometimes babies are born prematurely. You have to actually take judicial notice of that. Okay, court took judicial notice that persons who have been fatally shot sometimes linger for several days before death. It is common knowledge among lay persons that wounds which do not heal over long periods of time frequently become cancerous. Okay, and court judicially noticed that frequently persons apparently normal collapse from exposure to extreme heat or cold. Held a matter of common knowledge among laypersons that injections, we saw that one there. Refusing to take judicial notice that carbon monoxide gas is a poison. Oh, in a matter in which it operates. Wow. Judicial notice was taken that inhaling fumes, dust, and gases generate the manufacture of paint produces painter's colic or lead poisoning, a disease accompanied by great pain and often resulting in permanent injury. Poisons, when taken in sufficient quantities, cause severe injury. Court took judicial notice that lead poisoning is latent and progressive. Further noted as a matter of common knowledge that some symptoms of a given disease, particularly in its early stage, may likewise be symptoms of any one of several other diseases. Ooh, okay, so you take judicial notice of that. Ooh, that was a long section there. Let's jump over here to the chat if any of you are still here. See, juries decide facts and the law. A judge cannot strike from the record. That would be a court record moving right. So that's why there had to be specific instructions to the jury regarding judicial notice, that especially in a criminal case, they cannot be considered conclusive facts. And do advocates usually ask the court to take judicial notice, or is it common for the court to do that itself? Well, the court can, but it's usually up to the party that's trying to use it as part of their argument or their case or their averments. They would use a judicial notice as part of that to make their case, without having to go through the burden of bringing evidence that would be readily provable as facts to be used as evidence. That way you can get it in there a lot quicker, and things that, as long as the other party agrees too that it can be judicially noticed, they would have to have a reasonable objection to not have it noticed. Reputation of particular persons. The courts will not take judicial notice of the reputation of particular individuals, since this is a matter about which there might be a difference of opinion. Now, you can get the reputation of witnesses, but you can't take judicial notice of that, it seems. Similarly, a court may refuse to take judicial notice of the general public political reputation of particular persons. Oh, nice. And we finished this section. We're going on to the next section, which is economic and financial facts, which should be very interesting here, because this will be another adjunct to the business section, which we went over on the last live stream. So as we progress through the law of evidence, I hope this is becoming, I guess, to the extent where you can realize how intricate it has become through the course of American jurisprudence's development. A lot of it is a whittling away at the common law, as we've been seeing here. However, it doesn't mean that the common law doesn't still exist. It's just that it seems like there's been I guess would be a proclivity of deciding to go on case precedent rather than on principles of law and common law. So that being said, is there Any other comments here left in the chat? Let me give a quick refresh here and see. And I think we're pretty much up to date. Indeed, I see the last comment there from Bill Thomas. And so again, we saw some sua sponte, that the judges can, or the court can, take notice themselves of certain facts, but it's typically upon the party making, uh, taking the action or defending a point, whatever it might be, that they need those facts on the record to refer to them within their motions. And by having it judicially noticed, it saves the trouble of having to go through evidentiary process. Okay, well, I think we made it through this section. We'll be ready for the next one. So those are the incidents of human life that are recognized in a law of evidence concerning our judicial notices. And with that, I hope to see you all on the next one. And on your way out, if you could please, just make sure we get the algorithm going again, because we had a real low notification. I didn't even receive a notification. Kind of surprised that you guys even did. But I'm definitely delighted you were. And I thank you all for being here and salute you all for your commitment to bringing forth for fuller awareness of our tradition of common law and American jurisprudence. Peace out.